warrant file 24-6719FH.
For the record, Your Honor, Mike Roll on behalf of the people.
Morning, Your Honor. Larry Brown on behalf of Mr. Carr.
Good morning, and sir, you are Michael Justin Carr.
Yes, I am.
Mr. Carr, welcome. We were originally set to have you appear here in person. However, I was made aware this morning that you were lodged on potential new charges in Otsego County. So I instead allowed the attorneys to appear via Zoom, and I'm having you appear via Zoom as well. As you also know, we're here on two different things today. First was the bond violation hearing, or the contempt hearing, it's otherwise known as, regarding the alleged misses of the PBTs. And then secondarily on a status conference. As you also know, we were here last month, and when you attempted to enter pleas, I did not accept them. The long and the short of it is, Mr. Carr, while you were telling me that you were guilty, I did not believe that there was clarity in the record, and I refused to proceed. Do you remember all of that background?
Yes, I remember everything.
I'm sorry?
Yes, I remember everything.
All right. So, Mr. Carr, have you had time to talk with your attorney in between now and the last hearing date?
I did, just as I did before.
All right. So, Mr. Carr, are you ready to proceed today?
Yeah.
How did you want to proceed today?
What do you mean, how do I want to proceed?
Your
I thought
Honor,
we was going to jury trial.
Based,
You're two,
I thought we,
you're two
are we
open
not going to
options.
jury trial?
Well, Mr. Carr, let me explain as best I can. Last month,
Okay.
you attempted to enter pleas, told me that you were guilty and that you wanted to enter pleas, and I told you that based upon my perception, you were not making things clean and you were making them difficult on purpose. I told you that that was my perception and that I might be wrong. That's part of the reason why I originally was going to have you be here in person today before you got arrested on apparently new allegations. So again, the point from the court is two general ways to resolve the case is one, take advantage of a plea offer if you want to do that, or two, have me set the matter for trial. To the court, it doesn't matter as long as either way that we decide and you decide leaves a clear, clean record. So which way do you want to proceed?
Your Honor, I plead guilty to drinking 5,000 feet inside my driveway.
All right. Well, we're going to find out,
I
Mr.
was
Carr.
inside my driveway, 5,000 feet. I was driving and drinking, yes. Inside my driveway.
What I'm
I wasn't on
not
Alice Road. You got it written down as Alice Road.
Mr. Carr,
Mr.
Carr,
Carr, thank you for coming to be assisted, but I'm going to handle this right now. Mr.
Yes,
Carr,
sir.
the way this is going to go is one way and one way only. I'm going to ask questions, I'm going to get succinct answers from you, or we're going to be done with the hearing. I will not allow you to control the method or the operation of this hearing or to speak over me. Am I
Nor
clear?
would I try. Nor will I try, Your Honor. I'm
Just
not
try.
trying to.
Successful
I-
in doing. Mr. Carr, I'm going
I'm telling
to explain one more time while I'm confident that you can hear because now I've muted you and I don't have to hear you speaking. If the hearing digresses into anything other than my questions and your clear answers, we're going to be done. I'm going to set the matter for another hearing later. I'm not going to permit you to control the method of this hearing. That's my job and my role. Do you have any questions about that? Thumbs up would say no. Thumbs up, thumbs down would say yes. You have questions about it. Do you have any questions about what I expect? Mr. Brown, were you aware that Mr. Carr was lodged in the Otsego County Jail before I just let you know that?
oh, I'm sorry, Your Honor. Actually, we had a hearing in district court yesterday. I had spoken to him that morning. And when we actually went to court in the afternoon, he was lodged. So it was very, very recent.
Well, I guess the point was, I didn't know if you were aware of it or if it affects how you wanted to proceed today. Does it affect?
I was aware of it. I actually did have a conversation with Mr. Carr last evening. It was my understanding that we were going to enter a plea today.
All right. Well, I'm going to hear from the prosecutor and from you first. Then I'm probably going to unmute Mr. Carr and we're going to see what he wants to do. Can you outline for me what the terms of the plea agreement are?
Yes, Your Honor. He would be pleading to count 1 as a third offense and count 2 as well as the habitual fourth offense would be dismissed.
That accurate statement of plea offer, Mr. Roloff?
It is with the addition of the $200 blood test reimbursement fee to Michigan State Police.
That is correct.
All right. So I'm going to hit the button asking you to unmute through the Otsego County Jail there. So jail staff, if you could assist me with that by hitting the unmute button. Again, jail staff in the Otsego County Jail, if you could assist me by hitting the unmute button on your screen there. Mr. Carr, did you hear the things I've said so far?
Yes, I did.
Do you understand the things I've said so far, or do you want me to explain them again?
No, I've understood. I understood what you said.
Did you hear the terms of the plea agreement?
I heard the terms. Yes, I did, sir.
Do you understand them?
I do understand them.
Do you want to take advantage of the plea offer, or do you want to set the matter for trial?
I'll take advantage of the plea offer.
Raise your right hand. Other right. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Whole truth, nothing but the truth.
Mr. Carr, this plea agreement calls for you pleading guilty to the offense known as operating while intoxicated as a third offense notice felony. Are you aware of that?
Yes, I do, sir.
That offense is a felony offense. The maximum punishment is 5 years in the state prison system. The minimum fine for a third offense OUI is $500, and the maximum fine is $5,000. Then the law allows me to put you in jail with 30 days minimum up to 1 year in jail, or prison between 1 and 5 years maximum. At least 48 hours of that sentence must be served consecutively. Do you have a question, Mr. Carr?
No, he's raising his hand. I thought he wanted me to have my hand raised.
So I apologize, Your Honor, but I believe this would be a third offense.
All right. And so you understand you're pleading guilty to the OUI third as a third habitual. Is that right?
Yes, sir.
Thank you for that clarification, Mr. Brown. I did miss that. The third habitual has an effect on count one, and the effect is it doubles potentially the maximum penalty. Not potentially, it doubles the maximum penalty from 5 years to 10 years. Are you aware of that?
You're making me aware of it now, sir.
Now that you're aware of it, did you want to go forward with the plea agreement?
Yes, I will.
We went through the same exact terms of the plea agreement last time, did we not?
Yes, we did.
Has anything changed between then and now?
No, sir, nothing's changed.
So you understand the maximum penalties you're facing for count one OUI third as a habitual third, correct?
Yes, I do, sir. You just explained it to me just now.
You didn't get it explained to you last month, Mr. Carr?
Yes, I did. I had it explained to me last month also.
And you understood it then too, correct?
Well, I thought I did.
Well, do you
So I
understand?
didn't know this changeover from now. You was talking about from 5 years to 10 years.
Do you want me to explain it further, Mr. Carr, so that you can be very clear?
No. I'm just saying from what I knew last month and what I know now.
So you understand clearly what the maximum penalty is.
Yes, I do, sir.
You also need to be aware that the court can order you to engage in 60 to 180 days of community service. I can order you to engage in rehabilitative programs, and I can order the cost of prosecution and order you to reimburse the government for emergency response. A part of this plea agreement also requires you to reimburse the state $200 for the blood draw that was required. Are you aware of that?
Yes, sir. And I'm hoping you'd be lenient with me.
I don't know what that means, so why don't you tell me what you think that means?
I said I'm hoping that you would be lenient with my sentence.
Well, no part of this plea agreement has mentioned the word sentence, and that's because
No,
part of
it hasn't. You were talking about work pass, and you were talking about the programs. I was referring to the programs on work programs and stuff like that, sir.
Mr. Carr, the requirement that I have as a trial court judge is to make you aware of the possible penalties of a plea. That's what I'm doing. You need to understand that a sentencing hearing is a separate hearing entirely from a plea hearing. What I do at the sentencing hearing will be clearly explained to you, the reason I choose whatever penalty I choose, if I choose a penalty at all, and I'll explain that on the record at the time of sentencing. But nothing in this hearing has anything to do with your sentencing. This is a plea hearing. Do you understand?
And I gave my plea.
You have not
Plead
given
guilty,
your plea.
sir.
You're making it difficult to get a plea, Mr. Carr. That's why I'm taking breaks to go through things to make a plain, clean, and clear record. No part of this case today has anything to do with sentencing. Are you aware of that?
I understand that.
You need to be aware that if you plead guilty to the count one, operating while intoxicated as a third offense notice felony, the benefit of the plea agreement is that then the prosecutor would dismiss the habitual offender fourth offense notice. The prosecutor would also dismiss the second subsequent offense notice and the operating while license suspended, revoked, or denied charge. Are you aware of those benefits of the plea agreement?
Yes, sir.
Understanding then both the benefits of the plea agreement as well as the maximum penalty that you could face for count one as a habitual third. How do you plead to operating while intoxicated as a third offense notice?
Guilty, sir.
How do you plead to being a habitual offender third offense notice?
Guilty, sir.
If you plead guilty, you lose all of your current trial rights and you lose any automatic right to appeal. So that means following a guilty plea, you would no longer have any automatic right to appeal. You would have to instead seek what's called leave to appeal. Are you aware of that?
Yes, sir.
Trial rights that you would lose include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you would have a right to have the witnesses against you appear and to see, hear, and question them, and you would have the right to have the court order any witnesses on your behalf to appear at the trial. You'd have a right to remain silent during your trial and not have that silence used against you, and you would have the possibility of testifying if you wanted to at your trial. But if you plead guilty, those trial rights are gone in this case. Do you understand that?
Yes, I do, sir.
And because you're
But I
giving
thought
up your
we
right,
took in a plea. Well, I already
We're
gave
not.
you my plea, sir.
we're not there yet, Mr. Carr, and we're not there
Oh,
because I have stopping the proceedings, which are required as a matter of law, to explain things to you. So if you just listen to the questions I'm asking and then answer them,
I am listening.
perhaps you're going to get through this proceeding. If you continue to interrupt and ask or say things that are not responsive, I'm going to have to address them. That's going to slow things down. That's not going to be to your benefit. It's going to be to your detriment. One of the things that happens if you enter a guilty plea is that you will no longer be able to challenge things that you otherwise might have been able to challenge if you did have a trial. Do you understand that?
Yes, I do.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No one.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, they haven't.
Are you pleading guilty freely and voluntarily?
On my own, sir.
Are you pleading guilty freely and voluntarily?
On my own, yes, I am. Freely. Voluntarily.
And so a simple yes would save significant time. That's why I'm asking the questions as clearly as I can. If it's not a yes,
Yes, sir.
then don't answer. But otherwise, just focus
Yes.
on the questions and answer them. Do you
Yes.
understand that if you're a guilty plea and tell me that you're guilty, you're not going to be able to later change your opinion and tell me that you're not guilty?
Could you say that again? You cut out a little bit there.
Do you understand that if you enter a guilty plea and I accept it, and you tell me that you're guilty, you won't be able to change your mind later and come back and try to claim that you're not guilty?
No, I understand that fully. Yes.
Are you pleading guilty in this case because you are guilty?
Yes.
With respect to the charge of operating while intoxicated, is it true that you were here in Otsego County on or about March 18th of 2024?
Yes.
On that date, were you operating a motor vehicle?
Yes.
Was that here in Otsego County?
In my driveway, sir. Yes, it's Otsego County.
Listen to the questions and then answer them. Was it within Otsego
Yes.
County? Yes. Before you operated the motor vehicle, had you consumed alcohol?
Yes.
How much alcohol?
I don't know, sir. Probably 3-4 beers. I was in a pole barn.
So as a result of consuming those 3 or 4 beers, do you agree that you were intoxicated?
Most definitely, yes.
Did you take a blood or breath test?
I'm sure I did. I don't remember the scores though.
Counsel, can you help me out with a stipulation regarding what the blood draw result was?
Yes, Judge, I believe the parties would stipulate the result of the blood draw was 0.159.
I believe that is correct, Your Honor.
Mr. Carr, did you hear the terms of that blood test result?
Yes, I did.
Do you have any reason to dispute its accuracy?
No, I don't.
So again, do you agree that you were intoxicated at the time you were operating the motor vehicle?
Yes,
And do you agree that the place that you were operating the motor vehicle was indeed open to public?
yes,
Was it generally accessible by motor vehicles?
yes. That's what a driveway is made for.
Is it true that you were previously convicted of the offenses of operating while intoxicated, or excuse me, impaired back in 1982 in the 52-1 District Court in Novi?
I'm sorry, you cut it out again. Can you say it again?
To be previously convicted of the offense of operating while impaired on or about October 14th, 1982 in the 52-1 District Court in Novi?
Yes, sir. I did.
Were you represented by counsel at that hearing?
That I don't remember. I'm pretty sure I was, though.
Well, let's go through it this way. You have two different convictions. One was in Oakland County on 7/6 or July 6th of 2016 for the offense of operating while intoxicated. Is that true?
Yes, it was. I was in a car wreck.
In 2016, you were represented by counsel, correct?
Yes,
You were also convicted in 1993 in the Sixth Circuit Court for Oakland County of the same offense of operating while intoxicated. Is that right?
yes, sir.
And you were represented by counsel at that case, correct?
Well, yes,
Is it true that prior to the offense date here, so prior to March 18th of 2024, you had been convicted of at least 2 felony offenses?
yes, sir.
Was one of those felony offenses a armed robbery in 1998 from the Sixth Circuit Court for Oakland County?
Yes, sir.
Was one of those felony offenses an operating while intoxicated causing serious injury out of the Sixth Circuit for Oakland County on September 5th of 2018?
Yes, it was. Yes.
Counsel, is there an adequate factual basis to support the charge in the habitual?
People are satisfied. Thank you, Your Honor.
Defense is satisfied as well.
Do the attorneys believe the court's complied with the court rule regarding the taking of pleas?
Yes, Your Honor.
Yes, the court has complied.
Are the attorneys aware of any promises, any threats, or any inducements that have not been disclosed on the record?
None by the people. Thank you.
None by defense.
The court accepts your plea. Mr. Carr, I find it to be freely, knowingly, and voluntarily given, and there's a clear factual basis to support that finding. Therefore, I accept your plea and enter it on your record. The next step is the Department of Corrections is going to reach out to you to prepare a pre-sentence investigative report. I'm going to have you provide your phone number. That way they can reach out to you to the extent you're released from the Otsego County Jail. So go ahead with your phone number.
I believe that's it. Mr. Brown has it if one of my digits are wrong.
Well,
It's a new phone number, Your Honor.
let me tell it to you this way, Mr. Carr. It's your duty to be in contact with the department. If you don't get into contact with the department, then I'm going to revoke
No,
your
I'll
bond.
get in contact with him. Yeah. Okay, yeah, yes, sir.
It's your responsibility, not the department's, so that they can prepare what's called a pre-sentence investigative report. That document will tell me more about you and about your background so that I can impose sentence. The sentencing hearing will take place in about 30 days. You'll get a notice in the mail for that. That's going to be an in-person proceeding. Your attorney, the prosecutor, myself, and you all are going to be here in the courtroom for that sentencing hearing. Do you have any questions about
Yes, sir.
that?
No, sir, I'll be there.
So next up, we're going to address the bond violation regarding allegations of missed PBTs. Mr. Brown, what's your understanding of how your client wants to proceed on that matter?
I'm looking, Your Honor. This is actually quite a while ago, 3 or 4 months ago. I did have conversations with Mr. Carr regarding this. It's been a while, but it was my understanding we were just going to make admissions.
Is that accurate, Mr. Carr?
Yep. I don't know. Martha Holder's got the breathalyzer test locked up in the storage unit. She won't give it to me. And, I need somebody to tell her to bring it up to the courts and drop it off so I can get it back.
All right, that's a separate issue, which we'll cover. But Mr. Carr, is it accurate that you wish to acknowledge being in violation of bond conditions by missing PBTs?
Yeah, I didn't have the machine, sir. I started coming up here to the jail and paying it daily on that, but then I couldn't do it no more.
So Are you acknowledging that you violated bond conditions or not?
I guess that's violating the bond condition. Yes, Your Honor. I'm sorry.
Do you understand
I
that
just
if I
didn't.
find, do you understand
I'm
that
sorry,
if I find you, if I find you in violation of your bond conditions, I could revoke your bond, I could set a new bond, I could add conditions to your bond, or I could add the amount to the bond that you must post. Do you understand those potential consequences?
Yes, I do, sir.
Because of those, you have a right to a hearing, and at that hearing, the burden of proof would be on the people to prove that you did violate the bond conditions. Do you understand that?
Yes, I do, sir.
If you enter a guilty plea to violating the bond conditions, you lose the right to that contested hearing. Are you aware of that?
I guess I do. Yes.
And did you still want to go forward by admitting guilt to the bond violation?
I didn't think I'm guilty. I couldn't do it. But I mean, if you feel I'm guilty, I'm guilty.
Mr. Rowland, did you have your witnesses subpoenaed?
Yes,
I'm sorry, what?
We're going to have a contested hearing because I'm not in need of any further commentary from you on the bond violations. I set it for a contested hearing today. You decided not to enter a guilty plea.
No, let's go with it.
Let's go with what, Mr. Carr?
Why are you doing that? Well, I thought we was in compliance with what we was in compliance with.
We aren't in compliance with anything, Mr. Carr, because I just asked you what you wanted to do and you said you're not guilty. That means we have a contested hearing.
No, I said that I did not get all my PBTs in. Yes, I said that. I know I missed a couple of them because I couldn't afford them.
Do you understand that if I accept a plea from you as to bond violations, I can take several different actions that I've already repeated on the record about your bond?
Yes.
Do you still want me to hear admissions from you regarding a bond violation?
Yes.
Is it accurate that you were required as a part of your bond to take PBTs?
Yes, it is.
Is it accurate that you missed PBTs?
Yes, it is.
The court accepts your plea. I find it to be freely, knowingly, and voluntarily given. Counsel, do you believe I comply with the court rule regarding the bond violation plea?
people are satisfied. Thank you, Judge.
Dissatisfied as well.
The attorneys also believe there's an adequate factual basis for a finding of guilt as to the bond violation.
Yes, Your Honor.
Yes, Your Honor.
And regarding the bond violation, are the attorneys aware of any promises, threats, or inducements not disclosed on the record?
None by the people. Thank you.
None by defense.
The court issues a sanction of bond revocation relative to the bond violations. I'm not confident that without that, there's any reason to believe that you would either comply with bond conditions in the future and or frankly appear in court later. I also have a concern unresolved as of yet about why you were arrested last night. I'm not deciding to revoke bond based upon those things, but it is something that gives me additional concern. So bond is revoked. I will see you at your sentencing hearing. Do you have any questions, Mr. Carr?
No, I don't, sir. Thank you very much.
Mr. Brown, do you have any questions?
No, Your Honor. Thank you.
Mr. Rolla, do you have any questions?
No, Your Honor.
The court will get an order to the Otsego County Jail, which clarifies the bond revocation. We'll be in recess today.